Hello, everyone. Welcome to Career Launcher. Welcome to Career Launcher's YT channel exclusively for law aspirants. Today, we're going to look at a reading comprehension passage as usual, but this is based on a very interesting topical issue, hu- genre. You can call it law, legal, humanities. All right, we'll call it humanities. It's about 474 words long, so around the same size as your cat passage. All right, let's look at the passage. You're watching a recording of this, then read and solve the passage on your own while you mute the video, mute my voice, solve it on your own, and then look at the recording. Basically, I will read, summarize the passage for you, and then answer the questions. You have to read the passage once quickly and thoroughly so you have a very good idea of the questions and answers. It will help you answer questions faster and better. All right? Okay. The Supreme Court's prompt decision to initiate a three-member judicial inquiry into corruption allegations against Justice Yashwant Verma marks a welcome step. He's saying this is good. What the Supreme Court has done is good. The decision to publish the details of the allegations on the Supreme Court website, led by the Chief Justice of India Sanjeev Khanna and the Collegium, has been widely appreciated. So, first, the all the details of all the allegations against the judge have been put up on the Supreme Court's website, and that has been appreciated. So, there's transparency. Vice President Jagdeep Dhankar praised the move as a step in the right direction. The in house inquiry is now underway. So it started and it is continuing, led by Justice Sheel Nagu, G.S. Sadhavalia, and Anu Shivraman. India follows an adversarial justice system. What's an adversarial justice system? You have two opposites in the court, right? Adversaries almost, the prosecution and the defense, who put their sides in front of the judge. So we have an adversarial justice system where no one can be presumed guilty without due process. So they say presumed innocent until proven guilty. So no one is presumed guilty without due process. After you go through the procedure, then if you are proved guilty, then you are said to be guilty. Justice Verma has denied all wrongdoing, and he claims that he is the victim of a conspiracy. Despite public speculation, the presumption of innocence must be upheld. Now, Justice Verma has said these are all allegations, they are baseless allegations. I am the victim of a conspiracy. Public has been wild in its speculation, but we must keep that presumption of innocence. That principle must be upheld. Though Justice Verma may later reveal details of the alleged conspiracy, the public's readiness to believe the worst about judges raises troubling questions. He said, I am innocent, but nobody is willing to believe him. He said, this is a conspiracy. I will reveal that this is the details. But the public is only too willing to believe that the judge is guilty, and this is what is troubling. Nevertheless, the Supreme Court has taken administrative steps by transferring Justice Verma back to his parent court, the Allahabad High Court, and de-rostering him pending inquiry. So he now cannot serve. It's like a kind of suspension. He will not be part of the roster till he allegations are cleared against him. Although the Allahabad High Court Bar Association protested, their language was inappropriate. The courts must not be seen as dumping grounds for tainted judges. Transfers alone do not resolve the deeper concerns about accountability. The Allahabad High Court Bar Association protested, but their language was not correct. Because you cannot have, you can't have lower courts where you dump a judge with a questionable background. Transfers alone do not solve the question about accountability. The issue of bar associations calling for strikes was addressed in 2003 uh, in the Captain Harish Opal ruling, which barred the legal fraternity from disrupting court proceedings. So, can you imagine? court proceedings are going on, if the bar association itself calls strikes, the lawyers themselves are disrupting court proceedings, this cannot happen. The ruling emphasizes that whenever there is a complaint against judicial officers, it must be dealt with fairly and speedily. Dhankar also critiqued the Supreme Court's past decision to strike down the NJAC, National Judicial Appointment Commissions Act, calling it an unparalleled scenario. The NJAC amendment, passed with near unanimity in Parliament and ratified by 18 states, was struck down on the ground that it compromised judicial independence. So the Vice President was critical of the Supreme Court's decision to strike down the NJAC Act. Why did the Supreme Court strike down the NJAC Act? Because it sees it as a threat to judicial independence. Justice Jasti Chalameshwar dissented, arguing that the judiciary alone should not be seen as the sole protector of liberty. The Supreme Court struck it down, the NJAC Amendment Act, saying that it compromised judicial independence. But one judge dissented, saying that the courts are not the only protectors of liberty. Justice Kheher, writing for the majority, warned that the NJAC could create a reciprocity culture between the executive and judiciary, undermining judicial integrity. The NJAC Act was seen as something that would undermine judicial integrity. Critics often misrepresent the ruling as judges appointing judges, ignoring that presidential appointments continue guided by collegiums. It's not like judges are appointing judges. There's a collegium, and the collegium's advice is what is taken into account. Currently, appointments reflect a constitutional diarchy, to split between the executive and judicially, with both judicial and executive, both of them have powers. Diarchy, right? Two, both of them have powers, executive and the judiciary. Executive and judiciary both cooperate in judges appointment. Justice Verma's elevation involved both constitutional authority, suggesting that the current corruption case should not be used to reopen debates about the collegium system. Justice Verma's elevation to being a judge was involved both the executive and the judiciary. So the author says this should not be used as an excuse to start the entire collegium debate. Justice Madan Lokar, in his NJAC opinion, rejected the idea of a committed judiciary, concept reminiscent of the emergency era. He said the idea of a committed judiciary is wrong. It's just an independent judiciary. Similarly, veteran lawyer Ram Jethmalani's lone dissent in the parliament should not be forgotten. While allegations of judicial corruption stir public anger, they often mask deeper structural concerns. There's, of course, the public anger, but the bigger concern is there are deeper structural issues here. As the author argued in the Chimanlal Satalwad lectures, judicial independence remains vulnerable to pressure from trade and industry. The judiciary should be independent, but it's under constant pressure from the trade and industry. The challenges posed by neoliberal ideologies together call for renewed focus on ensuring judicial independence within dependence. It cannot be totally independent, but within its dependence, it should be given maximum independence. Question 1. What is the article's primary concern regarding corruption allegations against Justice Yashwant Verma? The need to reform the collegium system. The author says, let's not talk about the collegium debate at all. Public eagerness to believe in judicial corruption without trial, yes. And the author says this is very worrying. The failure of the Allahabad High Court Bar Association to act, no, they acted, they protested actually. And the author says inefficiency of the NJAC in handling judicial misconduct, but the problem is the NJAC has been struck down, so this is irrelevant to the case. So the author talks about what is concerning is public is ready to believe without any trial. It's ready to believe that the judge is guilty. Why was the NJAC Act struck down by the Supreme Court? The direct question in the passage, what has it been given? It was struck down on the grounds that it compromised with judicial independence, correct? It was passed without proper debate. No, it passed the majority in parliament, right? It would lead to delays. There is no mention of delay. It placed excessive control over appointments in the hands of the executive. Is it this, or it violated the constitution's prohibition on? The constitution doesn't violate prohibition, so it was struck down because it was against judicial independence and gave too much power to the executive, though not exactly mentioned, but we can infer that. Question 3. Why does the author What does the author mean by judicial independence within dependence? Courts depend on parliament for appointments, do they? Judges are entirely free from political influence. The author says how they are under tremendous pressure from industry and trade. Judicial independence is threatened by external pressures, especially from the industry. Courts must rely on public trust. This has not been mentioned. Therefore, C is the correct answer. They are dependent on others, on external things. Therefore, independence within dependence. C is the correct answer. What administrative action did the Supreme Court take in response to the allegations against Justice Verma? Immediate dismissal from judicial service? No. Transfer to the Karnataka High Court? No. Transfer to the Allahabad High Court, and de-rostering from duties. Therefore, the correct answer is C. Not D. C. D. Here it is D. That's why. Here it is still C. Huh. This answer here became D. Okay. Okay, in the answer key, here it is D, but here it is option C, transfer to Allahabad High Court. This became some mistake. All right, question 5. Which of the following best captures Justice Madan Lokur's view on a committed judiciary? It is essential for aligning the judiciary with national goals. He was against a committed judiciary, right? It was going against the tone. It is compatible with constitutional democracy, but then he did not want it. He said it would work against judicial independence. Necessary to no, it is constitutionally unacceptable and a harmful idea. What happened during the emergency? That the judiciary would be totally follow the executive orders, and that is compromising with the judiciary's independence. All right. Okay, I hope you answered all your questions correct. If you have any doubts, put it in the chat box. We will look at it and answer it later. If you have any questions about our courses, please call the number on your screen. I'll see you again very soon in another session on with another passage. Until then, bye bye.